Clerk may call the calendar. Thank you. And in the matter of In Re BM and the People versus BM, we welcome the Honorable Jonathan K. Renner, Associate Justice, Court of Appeal, 3rd Appellate District. And when you're ready, Ms. Horowitz.
Thank you, Your Honors. Good morning, and may it please the Court. Your Honors, the specific question in this case asks when a dull, typical butter knife can be considered a deadly weapon under California law. More broadly, however, the Court is being asked to evaluate what kind of evidence is necessary to support an assault with a deadly weapon adjudication when the defendant uses an everyday object in the assault as opposed to an inherently dangerous one. So the case is about sufficiency of the evidence, but it's also about the Court's interpretation of the legal standard that applies in this context, and that's the standard set forth in People v. Aguilar. Just to reiterate that standard quickly, for an everyday object to be a deadly weapon, it must be used in such a way that it was both capable of causing and likely to cause great bodily injury or death.
Counsel, when we're analyzing likelihood, what role does the fact, as in this case, that a victim might assert some sort of a defense play in our analysis? So what do we do, for example, in this case, with the fact that the victim deployed a blanket as a defense against the assault?
Well, I actually think that the record doesn't really set forth that there was a defense to the assault with the blanket in this case.
What's the distinction behind that? Just to unpack a little bit why that distinction you're making is so relevant here.
Because I think it demonstrates that it was not a defensive maneuver. So basically, when my client came to the room, she was holding the knife. She then pulled the blanket over her, which means my client only ever aimed the knife toward the victim when she was already covered in a comforter. And I think that matters, that she was never aiming the knife towards her skin. She was never trying to scrape her skin or anything to that effect. She only ever aimed it toward the bedding.
But in all of the standards that you have articulated thus far, and we recognize there are varying ones here, all of them will, to some extent, focus on actual use. Is that correct?
That is correct.
And that's a myriad of factors depending on what the object was, and force and size and intervening defensive actions or fortuitous actions, correct?
That is also correct. And if you look at cases where a defensive mover mattered, I think it's very clearly distinguishable from this case. For example, in People v. McCoy, that was a case where the defendant had the victim on the ground, was holding her, and had a sharp knife pointed directly at her neck. And in that case, the victim, I believe, kicked him in the groin and was able to get away. So that, it's very clearly a defensive move. I also think that in that case, you're using a much more dangerous weapon, so the likelihood of injury even prior to her kicking him was probably there. And I think it's also important to think about what type of speculation is proper when you're evaluating the likelihood. And I think, again, Justice Slow put it well when she said that courts should limit the speculation to the conduct of the should not speculate regarding the conduct of the defendant. That's the as-used part of the assault. So what the defendant did is what the defendant did. You don't speculate beyond that.
Right.
And I would note that in this case, both the respondent and the Court of Appeal, they have speculated regarding the conduct. They have gone outside the conduct that actually transpired here.
Before looking at the evidence, is it more likely than not that BM used a knife to cause great bodily injury or death?
I do not believe so. I don't think that this case even meets more likely than not. I think the risk of injury in this case was very, very small.
And can you, just for the record here, explain why you think that's so?
Sure. So when you look at the facts as they actually transpired and don't speculate beyond them, my client first goes to the kitchen and she chooses to pick up a butter knife. Notably, she did not pick up a steak knife. She could have. She's in the kitchen. But she picked up a butter knife. She returned to the victim's room. She stood in the doorway with the knife. The victim became scared. She said she was scared the entire time. She pulled the comforter over herself. My client then approached the bed. She said the victim was clear she never got more than within 3 feet of her, and she made swiping or slicing motions with the knife a few times toward the bed, toward the blanket-covered legs. No injury was suffered. There wasn't even evidence that the blanket had a tear in it or had any damage. No injury at all. And then my client stopped. She halted the attack on her own accord.
The Court of Appeal also ascribed some significance to your client's attempts to harm the victim by other means, by pulling her hair, by throwing a phone at her. What role, if any, should those background facts play in our evaluation of the issue in this case?
I think in this case and in most cases, facts like that are actually irrelevant. I think you're looking at the specific assault. Again, it's an as-used assault, so you're looking at the specific manner in which the object was used. So I don't think that in general, facts like that are outside the actual manner of use of the object at issue, I don't think those should matter, and I think they certainly don't matter here.
Good morning, Your Honors, and may it please the Court. There's just two issues I'd like to touch on. I'd like to address very briefly the question of law posed by this Court and then turn to my explanation as to why substantial evidence supports the particular judgment in this case. There appears to be no dispute at this point that a butter knife, such as described in this Court's question, can in fact qualify as a deadly weapon under Section 245A1. And indeed, California has a long history of finding that objects that pose less serious harm than a knife can in fact qualify under that statute. Obviously.
There is a definition in Aguilar that has the term likely in it. What do you think likely means in this?
Well, I think that Aguilar means what it says. It means that you look at the actual conduct of the accused, all of the factors involved, the nature of the object, what the accused actually did with that object, and ask yourself, is it likely that injury could have occurred?
Do you object to more likely than not as the fleshing out of the term likely? I mean, that's a very common standard in the law, and everybody knows what it means, so why don't we flesh it out as more likely than not?
If likelihood is not easily understood on its own, of course we want to provide more guidance, not less. But I think the Court wants to avoid any sort of bright line rules when it comes to the assault with a deadly weapon standard. There is no reason to categorically exclude a particular object or particular type of conduct from what might qualify as an assault with a deadly weapon.
Do you agree with the Court of Appeals reasoning that part of the substantial evidence inquiry includes, as the Court of Appeals said, that BM could have easily committed mayhem upon the victim's face? Does that matter?
I think that inference could be made based on the testimony as follows.
Okay.
That the defendant was on her back, knees bent up, blanket covering her, and felt the stabbing pressure through the blanket against her legs. So, under those circumstances, and also I'd point out that the victim says that her sister came into the room and came at her really fast, that this was a kinetic, dynamic situation. Defense counsel described BM as furious during this attack. And that's at page 31 of the RT. So, these are not facts that need embellishment. These are facts that it's perfectly reasonable for the trier of fact here to find, oh wow, in the hot anger of this attack, we are certainly lucky that there are no injuries to be addressed.
By the way, do we know how big the butter knife is?
6 inches is how it was agreed upon in the court. The DA said 6 to 7 inches, 6 inches, all metal serrated blade.
It's not a brie spreader.
No, it seems to be a regular utensil, a table knife.
Okay. Showing my great sophistication. So if she actually makes contact with her sister's leg, it is likely, however we define likely, that she might have bruised her, that she might have ripped the blanket, which doesn't seem to have transpired here. Would you say it's likely that that butter knife could inflict serious bodily injury or death?
I would, because in researching the potential harm for a butter knife, and I cited a bunch of cases in my brief, and I know that all butter knives are not exactly the same, and a table knife may be more dangerous than a butter knife, but butter knives have caused catastrophic maiming and death, including wounds to the leg. So absolutely, yes, I would say that it would satisfy the test. We have a violent knife attack, and these are the defendant's own words. I'm not embellishing anything. This is the victim saying, she tried to stab me, she tried to hurt me. BM says, I used downward stabbing motions. We have a 6-inch all-metal serrated knife. We have contact, significant contact, not de minimis. She felt it, described the amount of forces, pressure is 5 to 6 on a scale of 1 to 10. This is exactly the type of conduct that Section 245 is designed to deter and to punish more severely than just a simple assault.
So Aguilar requires that BM have used it in a manner likely. And we've talked about the use here of this weapon, and we've talked about its use in a way that, how do you best characterize the use of it that would cause death or great bodily injury?
Because this was used in a rage attack with a weapon. She is part of a continuum of angry assault. This was not done in jest. It was not done in retreat. It was not done in self-defense. It was done one person trying to hurt another person with a 6-inch serrated metal blade. This was not from across the room. This was in close proximity with actual contact and forceful motions.
Do those atmospherics, I mean, the anger, it's scary, it's loud, it's scary, it's fast, it's unpredictable, does that factor into use likely?
I think it does, because it shows that this is not a half-hearted attempt.
But it doesn't require anything but general intent.
Well, given all the circumstance, it seems like a pretty sincere effort to use a weapon to harm somebody, and I don't think that the statute requires anything more. In conclusion, again, when all inferences are taken in support of the judgment, as they must be, and all these factual disputes are reconciled in favor of the judgment, as they must be, clearly it was reasonable, based on this record and the testimony of the victim, BM, that an assault with a deadly weapon occurred here. I do not think that this is a close case, and I think that the judgment should be affirmed.
Thank you, Mr. Mercer.
Thank you.
Just a couple things, Your Honors. A quick note on the blanket. The record, again, it's very clear, and the victim stated that when my client came to the room, she covered herself in the blanket because she did not know what my client was going to do. The assault had not begun yet. The assault with the butter knife had not started. She didn't know what she was going to do. She covered herself. And that is relevant because my client saw that happen, of course, and knew that she was covered with a blanket and she was only using a butter knife. And I think that shows that the likelihood of injury was very small and that my client was not trying to do anything other than aim the knife toward the blanket. In addition, the anger that my client had, I don't think is relevant to the actual question here, which is, was this object morphed into a deadly weapon? You can be angry as you want and slam someone with a pillow in the shoulder, and that's not a deadly weapon.
Are you saying that her anger is irrelevant to the inquiry?
I believe to the specific legal question, yes, it is. And like the standard as set forth in Aguilar, I don't think that her anger is relevant to that. Regarding the likelihood standard, I don't think that likelihood means just more likely than not. And I think when you look at the way that likelihood is defined within other aspects of the penal code, I think that's clear. And I mentioned it quickly, but the felony child abuse statute, that's Penal Code 273A. And in that statute, the phrase likely to produce great bodily harm or death means the probability of great bodily harm or death is high. So I think that's what's contemplated by likelihood, and the common meaning of the term, and as it was used in Aguilar, should actually be more likely than not. Thank you.
Ms. Horowitz. Thank you, Mr. Mercer. The matter is submitted.